Hello, everybody. Just check you can hear me, because the reason for the slight delay was just a panic with my audio.
Morning, yes, yep. I can hear you.
You can. I thought you all couldn't then. I thought the panic was justified. Okay, morning. Okay, morning. Good morning. And I'll get started with our business meeting. My name is Tammy Swift-Adams. I and my colleague Karen Haywood, who's also here, are the reporters appointed by Scottish ministers to undertake the inquiry into the application for the proposed Earraghail renewable energy development made under Section 36 of the Electricity Act 1989. Just a short list of housekeeping points. I did quite a big introduction on procedural matters when we opened the inquiry in Tarbert on the 5th of March, and I won't go through all that again. I just wanted to, done the first one, check everyone can hear me, remind people that mobile phones and other devices should be on silent if you're using them, just so that they don't interrupt the discussions. And just to confirm, I don't think we're expecting a fire alarm test here today, so hopefully we won't be interrupted by one of those. The purpose of the business meeting today is to review the procedural arrangements that we'd previously put in place for taking evidence on aviation safety. We won't be taking evidence today or discussing the merits of the case, just the procedures we need to do in order to continue gathering that evidence. The purpose, of course, for the written and oral procedures that we'd previously agreed is to make sure that we as reporters are clear on the differences between parties on certain matters and the reasons for those differences. That's important to make sure that we ourselves can be clear when we're reporting our findings and recommendations to the Scottish ministers. So likewise, in terms of the procedures we're going to discuss today, our ultimate decision on whether we still require an inquiry session on this matter will be informed by the level of clarity that we achieve through these written submissions. And I think it's fair to say at the moment, we feel it probably is still likely we would need an inquiry session, but as I say, we'll see where we can get to in the meantime. I'll make a note of the discussion today, and I'll circulate that to you next week, and that'll act as a procedural note for these matters that we discuss and agree today. Are there any questions on those introductory points? Okay. So just move on to item 2, which is the attendee introductions. Most of us have met, or some of us have met previously, but for the record, could I just confirm who's representing the parties today, starting with the applicant, please?
Good morning, reporters. My name is Ewan MacLeod. I'm a solicitor with Shepherd and Wedderburn, and I'm representing the applicants today.
Good morning, ma'am. I'm James Finlay, King's Counsel, instructed by Sarah Wardle from Dentons and representing the airport.
Thank you. And is it just the two of you participated in the meeting today? Okay. So moving on to item 3, does either party have any update on aviation safety matters that they want to share before we go through the rest of the agenda? No. Okay. Item 4, look at the aspects of aviation safety that we think require further procedure. And the purpose of this item is to try and seek agreement on which aspects of parties' positions we think it would be beneficial to see further evidence on, that further written evidence that parties have suggested. Just as a brief reminder, the scope for the inquiry session on aviation safety was set out in Appendix 2 of the note of the pre-examination meeting as operational impact on Glasgow Prestwick Airport airspace, including effects on communications, navigation and surveillance systems, including radar and VHF. So on the agenda, I set out some bullet point suggestions for the broad areas that I think some of the disagreements maybe fall under. So we just wanted to consider whether probing these points further is necessary, and also whether there's anything else that we need to look at that might not be captured by those points. So I won't read the points out, they're on the agenda, but I'd just like to take each party's thoughts on that please, and have a bit of a discussion. So could I start with the airport, please?
Yes, there are only two matters that we wish to raise. One is, I think you received an email communication this morning that we think consistent, I think, with both sides' letters that led to the adjournment to the inquiry session. The CAA should be asked to comment on the applicant's further precognitions. And we, having thought about it, we thought it's better to do it in that broad sense rather than ask specific questions of them. It's fairly clear, they're quite short precognitions, it's fairly clear the points the applicants raised. We've made our position in terms of the CAA's input clear, and we think that would assist the inquiry. So that's the first point. The second point is and I have 3 points altogether, but the second point, and the only second question, is that the 4th, 5th and 6th bullet points relate to the mitigation agreement between the applicant and NATS, which I don't think we've seen. So in order to respond to that, it would be, we need sight of that mitigation agreement, and then there may be a need for some comment by the airport, depending upon what that prevails. The third and more general point is that the framing of the issues, if I can put it neutrally at this stage, causes us a little concern, but not that we need further evidence on, but we would certainly wish to, at some stage, have the opportunity to make submissions on. We're still hopeful that we can avoid the need for an inquiry, so that when it comes to written submissions in item 7, we would like the opportunity to put in what might in fact be closing submissions, subject to the need for an inquiry session, should you consider it appropriate. So those are the 3 points we'd wish to raise. Just by way of an example, in the first point, Mr. Hoogstraten's updated precognition sets out the framework in terms of airspace and airspace responsibility, maybe one word to use, but provision of services in it another, more or less accurately, but some of his commentary on it we consider to be unjustified. And it seems to us that that is a point better made by submission than by provision of further evidence. And that is far more likely to assist you further, particularly as to whether you then need a further inquiry session. But those are our 3 points on item 4.
I'll move across to the applicant then. I think one thing that comes to mind from what you said, Mr. Finlay, is just that perhaps at some point it'd be worth looking at where we can get to in terms of a statement of agreed matters. I don't think we've got one on this yet, and if there are areas you've seen in precognitions that you think you can agree to, it'd certainly help us to know what those were, the appropriate points in whatever procedures we agree today.
Yeah, no, I can see the sense in that, and that's something in terms of identifying the documents and identifying the framework against which certainly the first 3 bullet points need to be assessed. I'm sure is quite capable of agreement, and in reasonably short space of time, bearing in mind that both of us have an inquiry next week on a similar but not identical matters.
Okay. And the second point I'd just say is, don't be overly bound by those bullets at the moment. I wanted to put a framework in terms of, how you might work through some of the points of difference, but that doesn't mean it's comprehensible, that you need to stick to that if you think something else would be.
Oh, thank you, and I'm grateful for that indication. But that's one of the reasons we suggested framing a more general question to the CAA, because apart from that, in terms of the evidence we feel that is necessary to put before you, we are broadly satisfied that we have the evidence before you that we need to, but subject to the point on the mitigation agreement, and obviously subject to anything the CAA comes back on. but it's the CAA who under GAP 764 have the have a responsibility to provide impartial advice that you think you may be most assisted by way of further procedure.
Okay. And actually, another thought that I'll throw in at the moment is just that obviously we need to be clear where you feel you're already confident the answers to the points being made by other side are in your written submissions, and where you think there is a need for CEA intervention, which is why I've sort of certainly coming into the meeting, I was thinking it would be more helpful if it was a specific set of questions focused around the precognitions that we put to the CEA. I note you're at the moment, and as per your email, thinking that just a general, could you come back on this? These updated precognitions would be helpful, but certainly, in however we do this, it does need to be clear to Ms. Hayward and I where it is that you feel there is a need for CAA commentary, either in backup of something you've said or in answer to something that the applicants asked. So if that is going there in a broad sense, we still at some point do need to be clear where you feel the CAA absolutely needs to play a role and where you are happy with what's there already. Okay, so I will. Sorry.
I'll think about that while Mr. McLeod's making his submissions.
Okay, and I'll come over to you now, Mr. McLeod. I did say I was going to a few minutes ago, and then found lots to say.
No,
okay.
I'm very much in agreement with what you've just said. Mr. Finlay and I had a chat on Friday about the possibility of trying to frame some questions. You'd mentioned in agenda item 5 the possibility of candidate questions. And Mr. Finlay and I had a chat, and he suggested, as he has this morning, that perhaps a general question to the CAA asking for their comments on the precognitions would be the best way forward. I've got no difficulty with a general question being asked to them, but I take your point, which is that there may be specific issues that do require to be addressed. And with no disrespect to the CAA intended, they do have a particular way of writing, and it may be necessary to ask them specific questions to avoid a situation where we get a general answer that doesn't really take us very much further forward. So looking at the bullet points that you'd set out in agenda item 4, having discussed them with the clients, I think we're in broad agreement that those are topics that would be appropriate to ask questions about, and certainly we're happy to assist with that. In terms of the order that things get asked in, and this perhaps comes up slightly later in the agenda, but it looked to us like the first 3 bullet points were things that might be asked of the CAA and Glasgow Prestwick first. The 4th, the mitigation agreement between the applicant and NATS, is very clearly one for us to address. And I'll say a bit more about that in just a second. And then the 5th and 6th are probably matters that can't really be addressed until you've got the answers to perhaps the first 4. On the mitigation agreement, there are some issues of commercial confidentiality, and we wouldn't be in a position to share the full agreement with Mr. Finlay and his clients, and they'll appreciate that, given the approach that they've taken to mitigation agreements with my clients and others in the past. But what we will be able to do is we'll be able to explain to you and to him what the mitigation agreement covers and what it's intended to do and how it would operate. So I don't anticipate there being a difficulty for you or the airport in terms of understanding the significance of the agreement. It's just that we won't be able to actually share the agreement itself.
Okay. Thank you very much. So I agree there probably is a need for some sequencing of what we do, and as you say, we have got that coming up on the agenda as well. and I see your point that in terms of looking at there's the two stages you're suggesting. We look at some of the issues that we need CAA help for and get as much clarity as we can on those issues which are still unagreed or where there's those big differences, and then have as clear a view from the CAA as we can get before we look at what that means practically in this case in terms of anything that might need to be mitigated. Okay. And the point you make about making sure we get specifically what we need from the CAA, ideally first time, that's really why I'd come into the meeting thinking specific questions would be helpful. I wouldn't want to get to a situation where we say, what do you think about this? And then there are more follow-up questions based on the answer they have, because I think that's where we've been previously with the couple of issues the CAA have come in on before. So in terms of anything missing, parties aren't saying by the sounds of it there's anything missing from that set of bullet points, and that we can work through those points, but in the sequence we've discussed. Nothing people would want to add that they'd want to probe one another or the CAA on. Okay. I'll move on to agenda item 5 then, which is about the candidate questions. Oh, sorry, Mr. Finlay.
Well, it's just to come back to you on specific questions, but we're probably just coming to that in item 5 anyway. So
yeah, that's fine. Yeah, I am. Yeah, so you're right. So item 5 is the candidate questions for the airport. Now, some of you have probably got some of these lined up already, or I think there are some of them already sitting in some of the letters and precognitions that we've had. But what we really want to do when we go to out, by the sounds of it, first at the CAA, is have some clear questions that we know are going to get back the information that between us we all need to be able to carry on with the rest of the procedure. So I'll come to you first, Mr. Findlay, seeing as you obviously had something to say.
Yes, we still think that it would be worth asking the CAA to provide it or give them the opportunity to respond to any aspect of the supplementary precognitions. But if you, in terms of specific questions, looking first of all at Mr. Hoogstraten's precognition, if you have a copy of that in front of you, in paragraph 13, and I haven't prepared these, but this is in the in the context of his acceptance in paragraph 11 that the airspace forms part of the designated operational coverage area, whether the CAA's understanding is that the airport provides radar coverage within that area, and as to the importance of that coverage. And the second question is to ask the CAA to comment on the last sentence of paragraph 15, that the provision of services without using radar is safe. To ask them to comment as to the provision of such services in respect of aircraft. You'll have to forgive my terminological inexactitudes. If they're using IFR, then I think those two specific questions are, bearing in mind what the extent to which we think that evidence is disputed, would assist you. In terms of Mr. Wiley's supplementary recognition, there's a bit of an overlap, but in the end of paragraph 6, he also refers to the DOC, and at the end of paragraph 6 refers to the fact that it only relates to communication frequencies, and Campbellton Airport, for example, does not have radar. It's really the same question, the extent to which the CAA considers it's important for Glasgow Prestwick to have the ability to provide radar services in the area advertised in its DAC. The second question would be the extent to which, in respect of paragraph 7, the CAA considers that this is the last sentence of Mr. Wiley, that multiple agencies providing services in the same volume of airspace is inherently unsafe, whether they agree with that or not. That would seem to us to be an important issue for you. The third issue would be in respect of paragraph 11, the extent to which the CA considers that GPA are operating in somehow inappropriately in respect of aircraft arriving at GPA from uncontrolled airspace, if at all. The fifth point would be as to the relevance of NAT's service provision. They've said that they don't think it is. Well, they have said that they weren't aware of it, but whether now being aware of it, whether it changes their response. And the fifth point, if necessary, would be about paragraph 20 and the suggestion that it would be careless of a controller and a dereliction of duty to assume the service that a pilot would is requesting. So those are specific questions in respect to the precognitions, which may, I'm not suggesting they're comprehensive, but they, in our submission, I think they may tease out the more particular issues that those precognitions raise. But I would, in terms of questions to the CAA, reiterate our request to have a general, give them the general ability to respond to any issues that we haven't identified, as well as those specific points, if you consider those to be of importance. As far as questions to the airport are concerned, we haven't seen the mitigation agreement, so that the last three bullet points we can't answer. In terms of the first three bullet points, I reiterate our point. We consider that the evidence we provided is sufficient. We do want to make submissions on that material. We can either do that in terms of candidate questions if it's not about evidence, or we can do that later on. And as I said, a certain amount of those matters could be dealt with in a statement of agreed matters. And as far as questions for the applicant is concerned, that relates to the mitigation agreement. I understand what Mr. MacLeod says about that, and here, with interest, he's praying in aid that there's commercial sensitivity, and it's nice to hear that accepted. But we obviously need to know what the provision is, and if there's if it's suggested that there's a cost in it, some indication of the ambit of cost. So those are our submissions on item 5, unless I think what further.
Okay, thank you. And yeah, that's the type of approach that I think I had in mind really before we came in, looking at where there are specific things in those precognitions that you would like, you absolutely would like the CAA's comment on, and then allowing the CAA to comment on anything else it sees in those precognitions that it thinks it needs to comment on. So it's helpful to have those examples. I think you said they're not comprehensive. Do you think that within the space of the meeting, you'd be able to have a set that you would be confident was comprehensive, or would you need a bit of time for that? You're on mute. Mr. Finlay, you're on mute.
Thank you. Yeah, no, I was just trying to, I need to swap screens on my computer I think I was just checking nobody from the airport to come back. I think they're likely to be comprehensive. Yeah. In terms of, I've tried to identify the matters that are, not every matter, but the matters that are of importance. What we could say, if there's anything further, we could indicate that to you by close of business today. But it's not an exercise that we've done in detail because of the question we first raised being a general one, but we have discussed those precognitions in some detail, so I'm reasonably confident those are the main points we wish to raise.
Okay, thank you, that's helpful to know. I'll pass over to the applicant now then, please.
Thank you. Yeah, I mean, I think the points that Mr. Finlay raised are fine. We don't have any difficulty with those specific questions being asked. I was wondering, just as a general approach point, and this is looking at your timetable, you talked about issuing the meeting note or procedure notice by this time next week. And I wondered if the thing to do might actually be for the airport and the applicant to try and agree a set of questions now that we have agreement or a provisional ruling, at least from you, that specific questions would be helpful to you, and see whether we can do that by maybe not close of play today, but certainly close of play tomorrow. And that might help you by giving you a comprehensive list of all of the things that we both thought might need to be covered. In terms of other things that weren't mentioned on Mr. Finlay's list, I mean, you'll have seen my email from 8th April, where I set out a range of things that we say we haven't had an answer from GPA on. And one of the issues that we think is or may be relevant to the issues here is the question of what coverage GPA is currently able to provide in this area due to topography and so on. And that's set out in our inquiry report and is referenced in Mr. Wiley's supplementary precognition as well. I don't want to give you an off the hoof or on the hoof even question related to those issues, but those are the sorts of issues that we think might need to be explored in addition to those mentioned by Mr. Finlay in relation to the specific precognitions.
And in terms of that question specifically, and maybe some of the others that you've got in your mind, are they questions for the CAA? Are they saying you would want the CAA to, rather than GPA, to say what its current coverage was, or are you looking at the questions for the airport as well now?
It's a bit of both. So question for the CAA was, to what extent did it take account of any existing limitations on radar or VHF communications in the vicinity of Earraghail?
Okay. So obviously an agreed set of questions would be helpful. Coming into the meeting again, I think certainly I was anticipating you, Mr. McLeod, for the applicant, having a bigger set of questions already set out than the airport has. But is that perhaps not something you've got yet, a full list? I did see an email at the weekend saying you were still finalising that. Are you still, where have you got to in terms of finalising the questions you did have in mind?
I mean, I have a list of about 9 questions here, which I can read out to you, but it struck me that it might be better for you to get those in writing.
Yeah, okay, that's fine then. And you said that you would be able to get those today or tomorrow, ideally, combined with the airport's questions, which it sounds like fairly formed.
Yeah, I mean, my suggestion, if it's acceptable to you, would be I send an email to GPA's team early this afternoon, setting out our questions. They can have a think about them and add to them. I mean, I don't know whether you want them to say whether they agree with the questions or not. Ultimately, it'll be a question for you as to whether you want to ask them all or not, which I assumed was the point of describing them as candidate questions. So it will be your choice ultimately what questions you want to ask. We could suggest those that we think you might want to know answers to. Mr. Finley's team can add to those, and then you can choose which ones from that combined list you do want to ask.
Yeah, I think that would be helpful, and as you say, it's not necessarily a case that I would be looking to either of you to say don't answer that question, but as you've done just now with the questions Mr. Finley read out, you said you were broadly content they'd be, or you were happy with them. Let's put words in your mouth and say you thought they'd be helpful, you'd be happy with them, and I'm sure the airport will do the same. I mean, I'm sure if there's any major issues, I'd hear about that, but I'm not looking for agreement that those questions go. I just want a comprehensive list, basically, that between the two parties, we've got all of the questions that it's really key to hear from the CAA on at this point. So that I'm happy with that. If you are going to put send your questions to the airport, they can be added, and then we'll receive tomorrow the combined list. Okay. Does anybody want to say any more on questions at this point? Okay, thank you very much. 6 is provision of contact details, and you can perhaps just do this if necessary when you send that set of questions over. It's probably been covered now, but we had for the CAA Mark Deacon at this quite generic looking project email address as the formal CAA contact. We were subsequently given the contact name and email for Andy Wells by Sarah Wardle. So just if those questions can all just go to Andy Wells and Mark Deacon, that's fine. If there's somebody else, well, then it would probably be the airport that would know.
Yeah, I think unless we tell you otherwise, those are definitely the email addresses. Andy Wells was on leave last week, but we understand he's now back. So those definitely are the addresses. And obviously, if you send an email to them, copying us in, we will separately alert them to the fact that you've sent an email.
Thank you very much for that. I'll move on to item 7 then, which was the timescales for going about the further written submissions. I put down some bullet points really just as a starting point for suggestion, but they're really based on, you know, the normal intervening timescales we have when we've got an exchange of written. I think there's a bit more nuancing needed to this one because we're going to go to the CAA initially, and we may not be able to start on, or we want to start separately on some of the other questions between the two parties. We might want to add to this when we might see a statement of agreed matters, for example, as well. So could I start by taking thoughts from the airport on this? I've got the airport first because I think you might have the best idea of realistic timescales for CAA responses. You're on mute again, Mr. Finley.
I'm going to plead the Fifth Amendment when it comes to timescale on the CAA's responses. It's rather suggests we have some input into that, which would be limited. But given that they are identified in CAP 764 as having a role in providing impartial advice on disputes between applicants and ANSPs, I would hope within there's no reason why they shouldn't be able to do something by the 7th of May. So I don't have an issue with, I don't think we have an issue with that. In terms of a time for a statement of agreed matters, which might well Just trying to get my diary. It may well be if that again we could work to the 7th of May for that. We have a week following the conjoined inquiry when no doubt we'll be busily preparing our closing submissions, but I would hope that we could start provide you, particularly if the applicant took a lead based on the framework that Mr. Hoogstraten supplies, we should be able to provide you something by the 7th of May as well. And the other timetables look fine, subject to my point that whether you want submissions, fuller submissions before you determine whether or not you would wish an inquiry. And just given that there's going to be no availability in May, just jumping ahead to item 8, our availability for an inquiry, if needed, would be limited to the July week. So that would provide time for you to receive submissions and then make a decision as to whether you need an inquiry or not. And if so, could no doubt limit its purview to any particular issues you wanted to have examined further.
Okay, thank you. And can I hear from the applicant on the timescales?
I'll start with Mr. Finley's last point first, which is the July dates work for us as well. So if we needed to have an inquiry, then it's looking like week beginning the 29th of July would be available for everybody. On the timescales, excuse me, the only issue that I have with the final one for the 28th of May, we can work back from that, is I'm going to be on holiday from the weekend immediately before that, so something like the 25th or 26th. So ideally, I would hope to have a week. I won't be flying from Prestwick, Mr. Finlay will be pleased to hear. Ideally, I'd like to have a week to review whatever his final position is in order to respond. So we could bring that date forward or back to Friday the 24th of May. I'm hopeful that there's still enough time within May for us to work within the sort of general 2-week exchange time frame that you've mentioned there. Statement of agreed matters, I don't know whether it's helpful to try and get that done in advance of the or at the same time as the CA's submission comes in, or whether actually we should maybe postpone that by a week and everybody reflect based on what the CA has said to see whether there's more that can be agreed in light of what they've said. It's just a thought. I mean, I'm happy to aim for the 7th of May or roundabout then for a statement of agreed matters just between the applicant and GPA without any further input from the CA, but it struck me that it might be more beneficial to wait for a week after that. But beyond that, I don't have any further comments, I don't think.
Okay. We were moving your date back to the Friday, the 24th of May. Would that mean moving the date for comments on the information received back to the Friday before the 21st of May? Would that cause a problem for either party? So that would mean there was slightly less than 2 weeks for the comments, the final, the further comments coming back on what you've each seen from the first round of reps.
Just looking at my diary, it might cause us some problems. If we could have it by midday on Monday the 20th, hopefully that would give Mr. McLeod sufficient chance before he flies from a lesser airport on holiday.
How does that sound, Mr. McLeod?
Flying from a different airport to Prestwick sounds ideal. The Monday lunchtime is fine for me.
Okay, so I'll adjust those 2 dates when I send out the procedure notes. On the statement of agreed matters, I think it would be helpful to see one, even if it's just provisional, on where parties are or think they can be in agreement now based on what you've already seen, because certainly at the moment we're guessing on that. We've not seen anything really very much that says we agree with each other. So that seeing something on that as soon as the 7th of May would be helpful. And I agree then if you can narrow that down or widen it out, the agreed matters further, when you've got the responses from the CAA, again, that would be helpful. So shall I say the 7th of May for a provisional or an initial statement of agreed matters, and then I can add in the appropriate date for confirming any changes to that once we've got the CAA response. Okay, and I'll maybe put that, I'll just put that to code. Would that be sensible, coinciding that with that midday 20th of April date for comments on the information received? Or does it need to be slightly after that? Well, you'll be on your holiday, Mr. McCall. Who wants to give me a good date for that?
So for the statement of agreed matters?
The final one, yeah, when you've adjusted it post CAA.
I mean, I wonder if we would just go for the noon on Monday the 20th, because by that stage we would both have seen the CAA's submission for around 2 weeks, and any further agreement that we might be able to reach should be fairly clear before then.
Can I suggest that it would be nice to have some chance to deliberate on the statement of agreed matters, because they can chop and change. So I would again suggest, say, the Wednesday before that for the statement of agreed matters, just so that we, in making any final comments, we can draft those with a definite statement of agreed matters in mind. Otherwise, it can present difficulties.
So the Wednesday before Monday the 20th.
Yeah.
Does that work for you, Mr. McLeod?
That's fine for me.
Okay. I hope I've written down that in a way I can interpret afterwards. Okay, thanks very much. And I think we've partly covered the next agenda item 8 already, dates and document lead-in times for an inquiry session. If we're looking at the week beginning the 29th of July, and it's the Wednesday and Thursday. Can I just check, is it Wednesday and Thursday okay for both parties on that date?
They are, yeah.
Yeah, that's great. Then the other thing that I would need to do would be to check that I can set out lead-in times that will work in between those dates we've just talked about for the written submissions and the lead-in times. And I think there is enough. There's enough time in there. If we're getting all the written submissions completed by the 28th of May, then there would be time between then and right at the end of 2 months later for a normal lead-in time of any amended reports and precognitions, etc. Has anybody got any concerns about that? Or are you happy for me to set out those dates just for the normal lead-in times in the procedure note?
No, that would be fine. I think normal times in a procedure note, but I would make them closer to the prospective inquiry dates if we're going to have it, because one never knows. But notwithstanding, this is my first formal involvement in this case. Timescales for written submission may slip.
They may. So working back, yeah. Is that fine with you as well, Mr. McLeod? That makes sense.
It is, yes.
Okay. So I can move on to item 9, and we can pick up on any thoughts you've had since on anything we've already discussed as well. Any other matters that parties would like to raise while we are together, and I'll start with the airport.
No, nothing from us. Thank you very much, ma'am.
Okay, Mr. McLeod.
The only other thing, and I think it may have been covered. Mr. Finlay and I had a conversation on Friday, as I mentioned earlier on, and we talked about 2 documents. One was the MATS Part 2, which is part of the airport's licence, generally speaking. And then the second thing was any specific agreement between GPA and others about the provision of services in these areas. Now, I think that those documents may have been lodged in another inquiry this weekend. I'm not sure if they've been lodged for this one yet, but it is something that we think would be useful to you to have. By the looks of things, I've not read them yet, but it looks like we have the information I had asked Mr. Finlay for. But it was just to flag that that's something else that I expect you may find useful and may be lodged in due course.
Okay, thank you for that update. That hasn't sparked anything in you, Mr. Finlay, has it?
No, just in respect of those documents, absolutely, we were intending to lodge them in this proceedings as well. Mr. McLeod's seen them. As to the MATS Part 2, that is commercially sensitive, as I understand it. It's also a very significant document. So at the moment, I would resist any suggestion of lodging that. If Mr. McLeod has specific questions in respect of it, that may be a way around that issue. But I don't think that's certainly not lodged in the other inquiry. And we resist lodging that in this inquiry. But insofar as we can do, if there's a specific question in respect of what it contains, if Mr. McLeod wishes to ask us that separate from the procedures we've just been indicating, we can see whether we can provide an answer to it, and indeed potentially an extract dealing with the very specific point.
Yeah, to be clear, I don't want to see the full thing. This was mentioned in my email of 8th April. So I'd said that our position on which entity is responsible for the provision of air traffic services above Earraghail has been consistent. And then I'd set out 3 bullet points. And the second bullet point in that 8th April email was, sorry, just trying to read it. The applicant has not yet seen any thorough assessment by GPA of how the Earraghail development will affect the safety, efficiency and flexibility of GPA's specific operations. In order to satisfy that requirement, the applicant would expect to see appropriate extracts from GPA's MATS Part 2 or a letter of agreement with NATS demonstrating the extent of GPA's control over the airspace at the site of the proposed development. So it's that context that I was asking the question within.
Brilliant. In response, I think Mr. McLeod's question betrays several misunderstandings. One is that anybody has responsibility in uncontrolled airspace, because uncontrolled airspace is airspace which is not controlled. It depends how one uses the word responsible. If one is providing services in that airspace which is uncontrolled, you would no doubt do so responsibly. So one has to be careful about use of language. And secondly, there is no control. Just looking at his the extent of GPA's control over an airspace, no ANSP has control over uncontrolled airspace. So frankly, I'm happy for Mr. McLeod to ask us questions about MATS, but he needs to reconsider the terminology of his question first to properly identify what he wants.
Okay, so to make sure these points are discussed properly in the right place in procedures, just make sure in the set of questions that you're sending to us this week, you're perhaps including your questions to one another. Because obviously we might have questions that we're directing to each of you rather than all to the CAA. And then any documents, extracts from documents, clarifications about documents, or things you want to say about documents not being relevant, that can all come in at the relevant point, either when you're responding to questions that are put to you or commenting on what you see from responses to others. Does that make sense?
Yes. Yeah.
Okay. Thank you very much. Is there any other business for today? Okay then. Thank you very much for your contributions. I will close the meeting now and we will get the meeting note out to you. I've said early next week here. I'm expecting to be able to do that on Monday if we've got all of the questions we need from you in for that before the end of tomorrow. Okay. Thank you very much.
Thank you.
Thank you very much.
Bye.